community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner with over 30 years of unbroken service to the community is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Hello, good afternoon. You're welcome to today's show, with BWF Solicitors. I hope you're having a lovely day. Today we're going to discuss the topic, if one can apply to remain in the UK with their spouse without any immigration status. Can one apply to remain in the UK with their spouse without any immigration status? With me today is, as usual, lawyer Eunice Achampong, partner and solicitor at BWF Solicitors. You can watch us live on YouTube, Facebook at BWF Solicitors. May I also entreat you to share to all your contacts and loved ones. Let me quickly introduce lawyer Eunice. Hello, lawyer Eunice.
Hi, Vicky. How are you?
I'm good. And you?
I'm doing well by God's grace. How's the family?
Everyone is doing very, very, very well. Yes. Lawyer Eunice, before we start this program, we usually will ask you to give us some, latest news going around in the immigration atmosphere. So if you have any latest news for us in the previous week, please do then probably delve into today's topic.
Okay, that's fine. So as usual, when it comes to updates, there's always something changing in the scenes. And I remember last month I was saying that when it comes to our current migration bill, that is obviously ongoing within Parliament, and people have mentioned that obviously they are going to make things a lot more stricter, a lot more rigid. And if you don't have immigration status, they're thinking, would you be able to even apply from the UK? And it's more to do with solidifying the agreements they have with Rwanda. So I know last year was big on the news about the UK sending asylum seekers back to Rwanda because they basically do not have the capacity to take in that many asylum seekers. And so they have an agreement with Rwanda to obviously transfer those who come in as asylum seekers to the UK and then over to Rwanda. And
Okay.
so I know that when it comes to um, a lot of asylum seekers' claims, it is to do with the fact that there's a risk. There's a risk to those people's lives, and that is why they are fleeing their home country, or that's why they are fleeing where they are. And so,
Okay.
a lot of the time, if you have people coming to the UK, yes, they may have passed through other countries to come into the UK, but it is because they feel that they are most likely to be safe in the UK, or there
Okay.
are other family members here in the UK, and that is why they have chosen to come to the UK as a safe haven.
Mm-hmm.
And so the last time I spoke about the fact that once the agreement has gone through, they are most likely to send people off to Rwanda, because in the recent High Court case where they sort of put an injunction on the UK sending claimants or asylum claims, those who have claimed asylum to Rwanda, they had to obviously put an injunction to the UK doing so that they could hear both sides, from the government and from the asylum seekers, and whether it was safe for those asylum claimants to be sent to Rwanda. And obviously, because under the UN Convention of Human Rights, if you have first gone into another safe country, so let's say that you've um, moved from your country where you're at risk, and then you are moving into another country where it's safer, you would have to make a claim there, because obviously once you are in a safe place, you put in your claim so that you can remain there and then build your life there. But if for any reason you've managed to make your way to the UK because you believe that the UK is best suited to your needs, obviously there was one safe country you entered before coming to the UK. And so if the UK doesn't have the capacity, then they can, of course, say that they are sending you to another safe country, either the one where you came from or to Rwanda, where they have an agreement with the government. And so those are sometimes, should I say, technical issues, but that is something that the UK government has been seen to be acting in line with the UN Convention, and therefore they are not in breach or they haven't broken any rules. So yes, there will come a time when the asylum claimants who are coming into the UK will be sent to Rwanda or to the other safe country where they came from. And when it comes to, I know that people have been talking so much about deprivation of British citizenship when it comes to those who are British nationals now, and then having to then say that for some reason or the other, they may have misinterpreted information to the Home Office, or if it's come to light that they were involved in any criminal activities, or they've been convicted of any crime or terrorism, it is likely that their citizenship could be stripped from them if they have another nationality, or if they have should I say, means to receive passport from another country. So in cases like that, this mostly affects people from ethnic minorities, because maybe you are a second generation Nigerian and you're living in the UK and you're thinking to yourself, oh, but they cannot just strip your citizenship because you were born in the UK. It may be that you were born in the UK, but because maybe Nigerian law allows your parents to also register you as Nigerian, they can say, well, you can obviously take up your Nigerian citizenship because your parents are Nigerian, and therefore you can also be registered as Nigerian. So these things come into play, and it's important that when you are obviously thinking about getting your naturalization done and getting your British passport, that you put in the information as best as you can. It doesn't matter whether you've used previous names, it doesn't matter whether you've used previous dates of birth. Just disclose that information whilst making your application, and everything should be fine. As long as you disclose it, they know that you are being honest and truthful. The issue then comes in when you are not disclosing and you are not putting the information there as they expect you to. That is when they think that you have misrepresented information to them. You did not put information out there to them, and you should have. And so it is very important that we take note of these things when we are completing any form of naturalization applications, so that we don't become proud to this new laws about deprivation. Obviously, it's always been there. It's under our British Nationality Act of 1981 because it was amended, but they're now becoming very strict on these things, and the statistics of people being deprived of their British passport is going higher and higher. So I think that we should bear note when we're making these applications. If you can't complete the application on your own, then seek legal advice or seek legal support as well. Also, another thing I wanted to mention was the fact that when it comes to making applications for children, which is registration for British citizenships for children, there is a fee waiver for those children who are under the age of 18. So if as a parent, you cannot afford to pay for the child, there is a fee waiver application that can be completed. They want to know whether you can afford the fees. So if you are saying you cannot afford it, they will need evidence of your bank statements, they will need evidence of your pay slips, they will need evidence of all the bank statements you hold, all the bank statements of your children, all the
Okay.
yes, within the
Wow.
household. Yes, all the bank statements within the household.
Okay.
Yes, to be able to then say that this fee waiver application cannot hold. So it's important that as much as possible, you are able to show that you cannot afford it. And
Okay.
if there's anybody within the household who is also able to afford it, then they would say, why not this person pay for the fee? So it's a test of
Okay.
affordability. So we can obviously make sure that this is also adhered to. And then,
Okay.
especially for those who, for one reason or the other, may want to be making long residence applications. So when I talk about long residence applications, it's to do with the fact that when it comes to those who, for one reason or the other, have decided that they've lived here for 10 years lawfully. So under paragraph 276B, if you've lived in the UK for a lawful period of 10 years, you can make a long residence application. And so this is lawful residence. This is not you overstayed and you've lived in the UK for 10 years, so you're applying. This is lawful residence for 10 years. And you know that for one reason or the other, maybe on one occasion, you were not able to make the application in time. So you were not able to make sure that as much as possible, you were making the application within the time period that was granted. So You
Okay.
are saying that your leave expired before
Mm.
you were able to make the application for
Application.
subsequent leave to remain. If it is the case that you made the application within 14 days of your leave expiring, under paragraph 39E, you have to show that you have a reasonable excuse why you made the application within 14 days of your leave
Mm.
expiring. If
Okay.
you made the application after 14 days, unfortunately, you don't have any, should I say, excuse under the law, because
Okay.
under the immigration rules, a gap is usually something that is, should I say, after your leave has expired. So
Mhm.
they would say that the continuous leave has broken off
Yeah.
once you are able to say that, okay, this person, um, sorry about that. Let me just,
Okay.
yeah. So you are able to show that after a continuous period of 10 years, you've been able to have that consistent lawful residence. But if for one reason or the other, you're saying that there's a gap because I couldn't apply in time and I couldn't apply within 14 days, maybe it was because you didn't have the funds to do so.
Mm.
That may not be a good enough reason to say that you have continuous residence, because unfortunately the law does not provide you an excuse after 14 days. So if there has been a breach of over 14 days, that means that your continuous residence starts from when that last break occurred. If
Okay.
for any reason you were also convicted of an offense and you were sentenced, that will also cause a break to occur in your continuous residence. If you are saying that you were granted a deportation order, that will also cause a break in your continuous residence. So things like this, you have to pay very particular attention. I know
Okay.
that for child students, especially because they usually go back to their home country to make their applications to come back. So sometimes it might be that there may be a gap in the time their leave expired and the time that they were granted their next leave. But it is more so to do with when the application was made. Was the application made in time or was the application made out of time? And out of time means that your leave had expired before you made the application. So if it was made out of time and it was more than 14 days, you may not be able to give any reasonable excuse whatsoever, and therefore your leave would have to begin at the time your last leave was granted. So it's very um, interesting because the technicalities involved in that means that you have to be careful when you submit your application and make sure that it is not out of time so that you can benefit from the continuous residence. I know people have said to me, oh, I'm a parent or I'm a partner, I'm on the parent route. I made my application in time, and then for one reason or the other, maybe the home office got back to me after my leave has expired and they said I've made an invalid application. So an invalid application is, let's say, somebody who has made an application and then didn't do it on the right form, or they didn't pay the correct fee, or they
Mm.
didn't do their biometrics, or they didn't provide their passport. So that will make your application invalid. And so if the home office come back and they say, well, you haven't made a valid application and we are giving you 10 days to correct the matter, and within the 10 days you are not able to correct the matter,
Mhm.
unfortunately, you can make the application, but you have not made an in time application because the grace period they gave you, you were not able to comply with it. And therefore, you will be making an out of time application, and that will bring a break in your 10 years lawful residence. So we need to be very careful. We need to pay attention to these things and make sure that we are doing the applications at the right time and for the right reasons as well. Yeah. So I'll just leave that
right. I know there's definitely light at the end of the tunnel.
Yes. Yes.
Okay.
Yes.
Right. So, talking about today's topic, can one apply to remain in the UK with their spouse without any immigration status?
I mean,
human rights application.
Yes, this topic came to me at a time when I was thinking to, I was speaking to a client, and this client obviously was going through a situation where she has gotten to a point where she was even becoming physically ill. And this is something that a lot of people ask me. This question is not a new question. I think that this question cuts across the board. A lot of people would usually ask this question when it comes to them not having immigration status in the UK. So this is a question that cuts across the board. But the topic came to me when this particular client was with me and was talking, and she was literally becoming physically ill because she has tried so many other means and she was getting nowhere. So she just decided to pour her heart out, and she was just talking to me on a one-to-one basis, not even as a solicitor. And so I said to myself, goodness me, how can we help in this situation? When it comes to human rights applications, we thank God that we have the European Convention on Human Rights. And so that gives even British people who are no longer as part of the EU certain rights. And so under Article 8 of the European Convention on Human Rights, we have a right to private life and to family life. So a right to private life and family life in the UK. But that right is not absolute. So the government has a way of, should I say, has a way to regulate how those rights are exercised. So when it comes to things like public health, public good, the fact that they want to also keep to security, the government has every right to make sure that if it's going to cause any breach in those three areas, then they can breach your right to private and family life. And so it is always a proportionate or a balancing exercise that the government have to do if they are going to breach your right to family life and to private life. And so the UK government have put within the immigration rules how they will exercise their balancing act in terms of your family life and your private life. And so we know that when you're making an application based on your private life, the UK government have said if you have lived there for 20 years illegally, then we would want you to show that you have lived here for 20 years, and then you can make an application. Or if you are relying on your spouse or your children because you live here with your spouse who is British, or your let's say your children who are British, then you can make an application. So we're saying to you that you can make the application, but you have to show certain requirements. And so most of the time, what the government is aiming to do is to prevent crime from increasing. So to us as lawyers, we know that it is a crime to overstay when you haven't got the right to stay in the UK. And we know that it is also a criminal offense to enter the UK without valid leave. So they kept these things, by putting these laws in place so that people don't take advantage of their generosity. So when you say human rights application, it's to do with applications regarding your family life, you as a partner, or you as a parent. It is not to do with your extended family members. It is only to do with those that are, should I say, your nuclear family. Yeah.
All right. Okay. Okay. Ladies and gentlemen, if you just joined us, this is Bangina with BWF Solicitors, and I have lawyer Eunice Achampong here, Mrs. Pardon me, Eunice Achampong. She's a partner and also solicitor at BWF Solicitors. She's here with us today to discuss the topic, if one can apply to remain in the UK with their spouse without any immigration status. So this is the topic we are speaking today. Please send in your questions. If you want to text us as well, you can do so. Where you will be able to, explain to you and also guide you on what to do. If it is something that you will need to see her personally for guidance, she will leave the details at the end of the program, and you'll be able to book an appointment to see her. Right, Lawyer Eunice, who is a partner under the immigration rule?
Yes, so somebody also asked me this question as well. So when it comes to who a partner is, we know that it is not somebody who you've married. And so most of the time when you are referring to a partner under Gen 1.2 of our immigration rules, it is somebody that you have lived with in a relationship for at least 2 years. So you are in a relationship with this person, you've lived with them, and then it's for a period of at least 2 years.
Yeah. Okay.
And if you are saying that you are married to this person, then we want to see evidence of your marriage certificate. So under Gen 1.2, a partner is either somebody that you have lived with in a relationship for at least 2 years, or somebody that you are married to, but not a boyfriend or a girlfriend that you don't live with. It could also be a fiance as well.
So the living with the partner is very, very important. Some people like to say, in separately. One lives somewhere and the other lives somewhere, but they are partners.
Unfortunately, under the immigration rules, that's not even recognized. So they think that a partner should be somebody that you are living with. So a lot of the time you realize that when you are making an application on this route, they will ask for evidence of living together.
Right.
And so if you don't provide them with that evidence of living together, they are more likely to infer that your marriage is one of convenience. It is not genuine.
So is that decision made because of past experiences?
Well, they believe so. And so when you look at their guidance in regards to partner applications and then marriage of convenience, it is to do with the fact that they believe that once you say you are married, or once you say that you are a partner to this person, there must be evidence that you are living together, because they have immigration enforcement, and there are times when they have gone into people's homes and realized that they are not living as they said they are. So they really take these things seriously. Yeah. So the emphasis is on living together.
Right. Okay. All right. So what are the requirements to be met on the partnership under the Appendix F of the immigration rules?
Okay, so when it comes to our immigration rules, one thing that I always say is that there are eligibility requirements and then there are suitability requirements. There is, under the eligibility requirements, an exception to the rule. So if, for instance, I'm not able to meet a certain eligibility requirements, the exception may apply. The only requirement where the exception will not apply is to do with the relationship. So first and foremost, they want to see whether the relationship is genuine and subsisting. So if I'm saying that this person is my partner or this person is my husband, they want to know that this relationship or this marriage is a genuine marriage, it is a genuine relationship, and therefore I am showing evidence of my marriage certificate. I am showing evidence that we're living together. I am showing evidence of our communication, because maybe we are always calling each other on the phone or we are texting each other. And I'm providing any sort of evidence to show that even if I was previously married, that marriage has ended, and or I'm no longer with that person, and therefore I am now in a really new relationship and I am not married to so and so. If you're applying as a spouse, the requirement is that you should not be married to another person. And in this country, there is no bigamy or polygamy under the law. So, unfortunately, you cannot marry two different people at the same time. And the emphasis is also genuine and subsistent relationship. Of course, you should have met the person that you are going to marry. That's also one of the things that they require. You should be above the age of 18, and you should also be able to show that both of you are not related. So you are both not blood related, basically. So when it comes to the relationship requirement, there is no exception to that. Either you show relationship or you cannot make the application whatsoever. So relationship is key. The second requirement that they are also looking at is the requirement of you showing whether you have immigration status. So you are in the UK, they want to know, do you have immigration status? Do you have immigration status? So you showing them that maybe your leave has expired means that you do not have immigration status. Therefore, it means that you would have to be able to show that because currently you don't have immigration status, one of the exceptions should apply. So if I'm saying that the immigration status expired a long time ago because I came on a visit visa, then the exception has to apply. And then let's look at what the exceptions are under the immigration rules. So the exception 1A says that it will be unreasonable for the child that we have. So if the child is British or the child has indefinite leave to remain in the UK, or the child has lived here for a continuous period of 7 years, it will be unreasonable for this child to return to the country where you are from. So if there is a child in the relationship who is under the age of 18, and you are saying that it will be unreasonable for this child to return, then they will say this exception applies in your case.
Okay.
If there is no child in the relationship, then they are going to look at exception 1B. Exception 1B says that if the couple will face insurmountable obstacles to their family life or to their lives, then you have to be able to obviously make the application from within the UK. And the couple doesn't mean just the two of you as a whole. It means that either you or your spouse is likely to face insurmountable obstacles. So insurmountable obstacles has also been defined as they will meet harsh or great difficulties. So under case law, there have been a number of cases since this was introduced in July of 2012. And there have been should I say, thresholds by the courts to say that in meeting this test of insurmountable obstacles, which is this harsh difficulty, it would have to mean that the person who is the applicant or their spouse either has an illness or a exceptional situation where there is no way that it would be expected that the couple or either the partner or the applicant themselves will be able to return to their country of origin to make that application. And then, I mean, in 2008, there was a case of Chikwamba, which said that if the only requirement was that the partner had to return to make the application, then it would mean that in that case, the partner would meet all the other requirements, but they could make the application from the UK if that was the only other requirement they did not meet. So if you are saying that there are insurmountable obstacles, it must be that there is something which is very impending that is in your way that you cannot in any shape or form say that you are traveling to make an application from outside of the UK. So if I don't meet the immigration status requirement, I don't meet the financial requirements of 18,600 a year, I haven't done the English language test, or it may be that you have the English language test done, or you have an undergraduate degree confirmed by ACTIS, and you can show that your partner works and receives 18,600. But the only requirement you are not able to show is the immigration status. Then the exception 1A or B has to apply.
Wow. Okay. Right, Lawyer Eunice, I've got people sending in their questions. I've got Nikki. Nikki says, good afternoon, Lawyer Eunice and Vicky. Great show. I was told by a friend that I would have to return to my country of origin to make the application from there if there are no children involved. How true is that?
So, in Nikki's case, this is something that happens in most people. So most people that come to us as lawyers who have no immigration status will say to you, I want to get married. I want to know how likely or how possible it is to make an application. And you always say under the law, yes, you can make an application, but whether it will be successful is based on whether you can meet the requirements. So as I just mentioned before, if you are saying that there are no children involved, because you have to be able to meet one of the exceptions. So we have the eligibility requirements, which involve the relationship, your immigration status. The third is the financial requirement, and the fourth is the English language requirement. If you are not able to meet one of these three, which is the immigration status requirement, or the financial requirement, or the English language requirement, one of the exceptions has to be met. Either exception 1A or exception 1B has to be met if you are saying that you cannot meet either the immigration status requirement or the financial requirement or the English language requirement. It may be that you are able to meet 3 out of the 4, or you are able to meet 2 out of the 4. But you always have to be able to show evidence of the relationship. Once you are saying that exception 1A doesn't apply because I don't have a child, my husband hasn't got a child, myself and him, we haven't got a child together, so there's no child at all in this relationship. Is it likely to be successful? No. If you can't show that there is insurmountable obstacles to you going back to your country to make that application, they are likely to refuse it based on the fact that you haven't been able to show that there will be some great difficulty, or there'll be a harshness to them refusing your application. And I basically said that there are case laws that have come across just to show how high this threshold is. So it could be a terminal illness, it could be an illness where both you and the partner are experiencing it, and there's no way that you could get treatment from abroad. It could be that you are from a country where Boko Haram is also harassing people, and therefore within that place, there's no way that you could return, and you can't obviously be expected to go back to make the application from there. Or it could be, as the case is, you are in a gay relationship, and in your country of origin, gay relationships are not accepted. And if that is the case, you are saying that because you will face harsh difficulties, there's no way that you'll be expected to go back to that country to make such an application, because they would not see it fit for you
So,
to.
Lawyer Eunice, do you have to show proof?
Yes.
How?
So usually most people,
Especially those who are gays. I'm just imagining, how can you prove?
so we live in a country where evidence is key. If I'm saying that I come from a place in the northern part of Nigeria, and Boko Haram is the one preventing me from making the application from there, yes, my passport will show that I was born in the northern part of Nigeria.
Okay.
Obviously, if you went to school there, you will have evidence from your school and other evidence to show that this is where you are actually from. And so most of the countries where there are great difficulties or harsh difficulties, the government, or should I say the UK government, has had people do research on there. So they are called country policy guidance. And then with those country policy guidance, it shows what level of risk is there and how the level of risk can be faced or not faced. And so if I am saying I'm from the northern part of Nigeria, yes, I have to produce evidence that I am from the northern part of Nigeria. And then the evidence that maybe my family was in danger and therefore I cannot return back there. Right. You have to be able to produce that evidence. If you are saying that you are gay, you have to be able to produce evidence of you and your partner in a gay relationship. You have to be able to produce evidence that other third parties also know you to be in a gay relationship. It's not just you and your partner. So everything demands evidence. You cannot just say or state it that you are in a gay relationship. How are they supposed to believe that what you are saying is true unless you provide evidence? So you have to be able to provide evidence from third parties as well as your own evidence. And usually that is the case when we are making these sort of applications. If you say
the reason why I asked is because I know there might be situations whereby people may take advantage of the situation and say that because, in my country of origin where I come from, they really don't entertain gay relationships. So when I said evidence, I was thinking maybe threatening letters or anything to do with a threat on your life. Those things are very difficult to get. So I think the whole thing is telling the Home Office, this is the situation. My country really does not condone this type of relationship. And because of that, your life is being threatened, with evidence from close relatives and colleagues. Am I right?
Yes. So it has to be people that know you and then can state something. So they have to be able to write something to that effect. Threatening messages, I'm sure you will get a lot of that if people know that you are a gay person and you are from a country where this is not accepted. You will have loads of evidence, and believe you me, I've met people who have shown me messages on their WhatsApp and all of that, showing the messages that they've received from people, the threatening messages that they've received from people. So that too is very crucial if you are able to.
How about those who, are afraid to come out, but they are?
Well, you're now in the UK, so most of the time when you're in the UK, there's nothing like they're afraid to come out. They show who they are. I'm yet to meet somebody who hasn't really shown who they are. But if that person is already married, and let's say that they are now saying they are gay, then they will need even more evidence to show that they are indeed gay. Because if you were straight and you were married, now what happened? Why are you now saying that you're gay?
Oh,
so
okay.
you need even extra more evidence to show that that is the case. Yeah.
Okay. So Nikki, I hope Lawyer Eunice has answered your questions. If you are still not clear with the explanation Lawyer Eunice has given you, she will leave her details at the end of this show for you to contact her if you need further advice and assistance. If you've just joined us, this is hanging out with BWF Solicitors. I would say BWF Solicitors is one of the top law firms in the country, should I say. They also have a branch in Ghana as well, and they specialize in family law, immigration and nationality, Ghana law practice, dispute resolutions, and many more. If you want to send in your questions, we are here for you. Free consultation. After this show, if you contact Lawyer Eunice, you would have to pay for consultation. So jump on this opportunity and send in all your questions in relation to this topic, and Lawyer Eunice will be, very happy to answer your questions. Right, Lawyer Eunice, I've got, this is a very long question. And Nana says, I have met a lovely, Nana, okay, I think it's a woman, Nana, my apologies. I have met a lovely man who wants to marry me. I told him my circumstances, and he has agreed to help me sort out my immigration status. He's settled in the UK and has 2 children from a previous relationship. They live with their mother and their father sees them on a weekly basis. What are the chances of the application being successful if I were to apply in the UK as his wife?
Okay, so I think she's got more of a chance. I know that these are not her children, and they are the man's children. So as I previously stated, you have to be able to show that either you meet exception 1A or you meet exception 1B. So if there is a child or there are children in the relationship, then you stand a chance. I've recently dealt with a case where similar to this, obviously the children were being looked after by the stepmother as well. So they would come and stay over and all of that. And in that case, even though they were not her own children, the judge said that, yes, there are children involved. And in her case, because she doesn't have a parental relationship with the children, which is she's not the biological parent of these children. So he considered exception 1B. So exception 1B is the insurmountable obstacles, isn't it? Where they're saying that there's a harsh difficulty to them going back to their country of origin to make the application. But because obviously the parent to the children is the husband, they said, this man cannot be expected to go back to the country where you are from because he has children here in the UK. He has a responsibility towards his children, and therefore this will create a harsh difficulty to these children if their father were to go back with you to another country. And so in that case, you as the stepmother, because it will be harsh towards your husband, we will allow the appeal. And I was like, amazing. So we thank goodness that we have the insurmountable obstacle being split in two. So it's not just a harshness towards you, the applicant, but also towards the partner. So in this instance, yes, if it is the case, as in Aslam and as in the recent case that I just mentioned, that when you have children in the relationship, they may not be yours, but because these children are British or because these children have settled status in the UK and their parent plays a role in their life, you as a step parent will also be able to benefit from it because of the fact that it will be something that is harsh for the other parent to return to your country of origin to form family life there. And so in this instance, yes, Nana has more of a fighting chance to basically make the application. It may be refused by the Home Office, but be rest assured that when you go for appeal, the courts will look at it favorably. And so, yes, if there are children involved, you can make the application. And if the father is very much involved in the children's lives, that would help greatly. Yes.
Right. So, Laura Eunice, talking about children, does
Yes.
that mean in any application, if children are included or involved, the success rate is higher as compared to couples or partners who put in an application, without any child involved? When children are involved, does it guarantee a higher success rate?
So, I mean, it looks like it. At the beginning, I was saying that the right to family and private life is a right that is not absolute. So the government has a way of regulating or limiting your right to family and private life. And that is why they have said that these are the requirements they need. And if they believe that you are a threat to their immigration laws, they will put certain rules in place to prevent that crime from happening over and over again. So, like I said in the beginning, the only time that obviously you can say that you are making an application based on your family life is when you are saying you have a partner or when you have a child who is British or settled here in the UK. And if you are saying that you are making this application on your family life, they have then put further rules in place to say that these are the only instances that we will consider whether you can remain here in the UK. And so if you are saying there's a child who is under 18 in the relationship, then your chances of your application being successful are greater. If you are saying that you are alone and there isn't a child, then you have to be able to show those harsh difficulties. Unless you can show there will be some level of hardship or harsh difficulties to you as a couple or to you as individuals, then unfortunately you are not going to get the best outcome. So the threshold is high, like I said. If there's no child involved, you have to meet that high threshold. And if you can't meet the high threshold, then they would always say it is better that you go back to your country of origin and make the application from there.
Wow. Okay. Right. So I guess this is what time will permit us. Laura Eunice, if you could quickly just summarize what we've discussed so far, then leave your contact details. I've got people sending me messages. Laura Eunice's address, they just want to have your address. So hold on a minute. Laura Eunice will do so just under a minute. So Laura Eunice, just summarize what we've discussed so far for the benefit of those who've just, joined us.
Yes.
I will also take this opportunity to advise those who just joined us that you can go on BWF Solicitors YouTube page. You have a recorded version and you can watch from the beginning to the end. So don't worry, you've not missed anything. You can do so on our YouTube page and also on Facebook. So over to you, Laura Eunice.
Thank you so much, Vicky. Yes, so when it comes to our topic for today, I know that this is something that cuts across the borders, and a lot of people do ask when they don't have immigration status whether they can rely on a spouse to make an application. Yes, as I said, there are 4 requirements under the eligibility rules that you have to meet. You have to meet the relationship requirement, you have to be able to meet the immigration status requirement, you have to be able to meet the financial requirement and the English language requirement. Under the financial requirement is also accommodation. So you should be able to show that you have suitable accommodation as well to be able to meet all of those requirements. If for any reason you can't meet 1 out of the 3, so you definitely have to be able to show the relationship. If you can't meet the immigration status requirement, or you can't meet the English language requirement, or you are not able to meet the financial requirement and accommodation, you have to be able to show an exception. And then under the exceptions to the rules, either you have a child who is under the age of 18 who is British or settled here in the UK, and you are saying that this child, either they have EU settled status because they're a child of an EU national, or you are saying that because this child is somebody who has lived in the UK continuously for a period of 7 years, there is no way that this child can return to your country of origin. So it will be unreasonable. And if you are saying that this is the case, then they would apply this exception to your case.
Okay.
If you are saying that there's no child in this relationship, maybe I'm a step parent, but the person that I'm with, his children are above the age of 18. And so there's no way that I can show that there are children involved in this relationship. And I myself, I'm not able to have children. So the likelihood of children coming into this situation is very unlikely. Then they are saying, definitely you have to be able to show that there will be insurmountable obstacles to either you or your partner returning to the country where you are from.
Okay.
So this test of insurmountable obstacles, the definition under the immigration rules is that there will be harsh difficulties to you and your partner. And that could be examples of what I gave, where if there has to be a terminal illness and there's no treatment in the country where you're from, or you are less likely to be able to afford it in the country where you're from. And then I also gave the example of Boko Haram. Maybe there are terrorist activities in that country where you're from, and therefore, because you are particularly from that area, and there has been risk to your family members and other people, there's no way that you could return back to that country. Or it could be that the country where you're from is so strict on certain rules, including homosexuality. And therefore, because there's no way that they will allow that lifestyle, you cannot go back to that country to make that application. And these are high thresholds because the Home Office has guidances as to the risk that people face in different countries, and they have policy guidance to show how high the risk is and how low the risk is. And so it's quite a high threshold. And if you can show, like in the examples I've just given, that there is a threat or there will be serious hardship or harsh difficulties to you or your spouse continuing in that country, your life's continuing in that country, then it is likely that the Home Office will grant you leave to remain. If it is not the case, then it is less likely that that will happen. So, like you were saying, having children in the relationship definitely helps to make sure that your application is successful. If not, under private life, if you can show that you have lived in the UK for at least a period of 20 years, then it is likely that you can make the application based on your own self, based on your private life, to show that you have lived here for a period of 20 years and you would like to make a leave to remain application. Yes. So yes, we are BWS solicitors. We do not only deal with should I say immigration law, but we also deal with nationality law, and we also deal with family matters such as divorce, child arrangement orders, child protection, things to do with non-molestation, occupation orders, civil litigation matters. And then we also now deal with wills. So our senior partner, Mr. Bernard Owusu, deals with wills. And so if you are looking to have a will drafted, you don't have to be dying to draft a will, because now a lot of insurance companies are now having a lot of claims issued because you never know when it will be your time. So you can draft a will and just put it down just for a rainy day. So yes, we are situated in London. Our address is the 4th floor of Anna House. So 4th floor of Anna House, 214 to 218 Tottenham High Road. And it's London. Postcode is N154NP. So N154NP. Our telephone number is 0208 493 7340. So it's 0208 493 7340. We are usually open from Monday to Friday, 9:30 a.m. to 6 p.m. Do give us a call. We can put you in for a consultation, and then you can obviously come and see us too in regards to whatever issues you have.
Great. So, Eunice, thank you so much. I think talking about wills, we need to find time and also discuss it and try and encourage more people to, engage a solicitor to draft their wills. Like you said, people wait till the last minute when they are on their dying, bed. Then just clicks, I need to draft a will. So it's very, 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 but it's one thing that we always overlook. You ask yourself, I don't think I'm going to die.
I know, right?
Now. I don't think I'm going to die now. Nobody knows. So that is also one thing that we probably can conscientize and educate the public on the importance of having a will drafted. Especially when you have dependents. So, So on that wonderful note, I would like to say thank you to the team of the BWS solicitors, Lawyer Eunice and her team, and for always coming our way to educate us and also guide us on, the right path towards sorting out our immigration issues. Lawyer Eunice, thank you so much. So till we see you again another time, take good care of yourself, and we'll come your way with another interesting topic. Until then, stay blessed. Bye-bye.
Bye.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.